Today we learned who will preside over the federal criminal case against former President Donald Trump, at least for now. It is Judge Aileen Cannon, and if that name sounds familiar to you, it is because this is not the first time she has been involved in this case. It was Judge Cannon who, earlier in the classified documents investigation, appointed a special master to review the thousands of documents seized from Mar-a-Lago, stalling the government's investigation. A higher court later overruled her. And it will be Judge Cannon who oversees Trump's arraignment next Tuesday afternoon and determines whether to set a trial date before the 2024 election. I am joined again by my esteemed colleagues Stephanie Ruhle, Andrew Weissman, and Ari Melber, and I want to welcome to the desk the great NBC senior legal correspondent Laura Jarrett. All right, Laura and Andrew, this question is especially for you. I'll start with you, Laura. But Aileen Cannon, controversial figure in judicial circles and in media circles and on just casual onlookers. How did she get assigned this case, and truly how much power does she have at this moment to derail it?
To hear it from the public information officer down there, this is supposed to be a random assignment, despite the fact that she does have some past history with this case. There's not some related case doctrine. That was a civil case. This is a criminal case. This was random. There is some issue about exactly what the pool of judges might be. I know there's some reporting out there that suggests the pool might be as many as 15. We think it actually might be a little bit smaller than that. Put that aside. The point is the Justice Department has to be feeling a little bit of heat about the fact that this is the judge that they pulled, and this might be the judge that they're stuck with, and this might be the judge that does have the power to either slow this case down a lot or dismiss the whole thing.
Yeah, well, and that's a dramatic amount of power, Andrew. As much as people are saying, look at this indictment, it's artful, it's watertight, Aileen Cannon could basically squash this whole thing.
So she has enormous power. I do think that there are limits on could she get rid of the whole thing. That's where
or delay it until it becomes
exactly
untenable.
In other words, if she's smart, which so far I have to say her rulings have not been. I mean, her rulings were reversed twice by a conservative court of appeals. So she has not really shown her best. But it would be, if she did the dramatic step of just dismissing the indictment, I mean, you have to have a reason for that, and that can be appealed. So I'm less worried about that. There's another way to do it which is much easier and very hard to appeal, which is just delay.
Yeah.
And so you sort of essentially accomplish the same thing that you're saying, but you just say, you know what, my calendar is really busy and we're going to have a lot of discovery and we're going to have a lot of motions, and this gets put off. That could be quite problematic.
Isn't that exactly what Donald Trump wants?
Of course, delay. I mean, any defendant wants delay. There's this famous euphemism about, for when you're a defendant, an adjournment is an acquittal. This is because no defendant is really thinking.
Right there.
Yes, exactly. I got a little laugh.
Not only in the room, but around the country.
Yes, exactly. This is
your audience right here.
Yeah, an audience of maybe one. I do think that one of the things that the Justice Department has to be thinking now, and really Jack Smith, is what are their options? One is to really drill down on how did this actually happen? Is it purely random within the pool of judges, who are in the right location and could hear a case that is at least this long? So there's reasons to think that it could have been random within a very small denominator. So that's how it happened. But because of her prior rulings and just how sort of bad they were, and that's not me, that's the 11th Circuit twice saying that, does that give enough ground for the government to try and say you should recuse yourself? That is a hard road to go down. Or do they
force a recusal, or can they just request it? Right? I'd like you to recuse yourself.
No.
Holds nothing.
Yeah, you can make a motion for it. You have to have grounds for it. Usually the judge themselves.
But does she get to decide?
She gets to decide, but a chief judge also can decide. So but again, it is not something that first the government has unilateral power at all, and it's a very hard thing to do.
But just to point out, the special counsel's office has proven itself to be way ahead of just about everyone. Nobody even knew they had the second grand jury open until recently. Nobody knew they had the Corcoran tapes until the New York Times advanced that in the past weekend. We've learned a lot just in the past 2 weeks. And Andrew has pointed out that they also had heavily researched the circuit split for the possible venue appeal if there were a double jeopardy claim, which is very arcane. I say it that way on purpose, which is to say they've been ahead of a lot of things. Mm-hmm. They know about her because of the history you reported, Alex. So they obviously have to have been ready for, if we bring this in Florida, we could get different type of judges than you might in D.C., and they went forward that way. So they certainly have to be prepared with some plan B and C here.
But it's the Corcoran notes that she might actually keep out. That's the thing to keep your eye on.
And that, I think, is cause for great concern given this indictment. We're going to take a quick break. And Laura Jarrett, as we were going to break, you started talking about one of the crucial roles that the judge assigned to this case, Aileen Cannon. One of the crucial things she can oversee, which is the submission of evidence, which evidence she's allowing into this. Mm-hmm. Talk to me a little bit more about what she might want to stop from being presented as evidence in this case.
One of the things we now have a better view of is exactly what prosecutors wanted Evan Corcoran for. We knew that they were able to pierce through the attorney-client privilege, which is viewed as sacrosanct. That's not a small thing to be able to pierce that privilege. But in order to do that, they have to show that the advice was used in furtherance of a crime. And we now understand much better than I think we did even before, even though there was so much great reporting. Obviously, Trump's attorneys want to keep that out. That is very damning evidence, and they will file motions to try to exclude it, and those motions will go to Judge Cannon. And so she takes out all of the notes that he transcribed in this narrative form, and he was clearly disturbed by some of his interactions with his current client. Let's make it clear. He's still a client. He may not be a client on this matter, but he is, at least as far as we last checked, still representing him as it relates to January 6th.
Well, yeah, and Andrew Weissman, you point out, will he be a lawyer for Donald Trump longer than a ripe peach can sit on a grocery store shelf, to borrow a metaphor? Yes. You know, it seems like there could be an appeals process involving Judge Aileen Cannon.
Yes, but to that point, she makes a crazy ruling that keeps something out. They have to appeal it. Delay. She makes another crazy ruling. They have to appeal it. And at that point, if it goes past the election in many ways, Donald Trump gets what he needs. Which is the trial not happening before the election. And just to be clear, that's something that the American public is hurt by that. And the American public, whichever way the jury goes, really should have a decision on this. And frankly, even if you were Donald Trump, you would want that. You'd want to be like, you know what, I want to be cleared by this. And, so there really should be, if you were an honest broker, you would be trying, if you were a judge, to say, consistent with due process to the defendant, this should go as fast as possible because the public has such a vital interest in knowing what happened here.
Well, and let's just also say this isn't the only investigation. Jack Smith's probe into Donald Trump's role in the January 6th insurrection is ongoing. There's, of course, Fani Willis, the DA down in Atlanta. There's a lot of calendaring that has to happen, presumably, in the coming months. Plus, that thing, a 2024 presidential bid. Yeah, when we heard from Jack Smith today, he spoke briefly, but he made a point of saying the defendant, for his own rights, deserves a speedy trial. And this will also be another testing point. Yes, as we've discussed, there are people who are fully bought in or minds closed. There's a lot of Americans who want to see what's happening. And if you are running for president and also trying to run out the clock rather than deal with the facts, that is a bad sign. That's separate from your legal process. But again, this isn't someone, Donald Trump, who, as the nominee last time, exactly won people over or won over independents or independent-minded veterans and national security folks. So he's legally presumed innocent, and if he can win in court, bless. But running out the clock to avoid your day in court is not the right look.
You had said a moment ago that, Jack Smith was prepared for this, that it could be Aileen. How much of a blow is it to Jack Smith that she was, in fact, selected?
Well, it's a great question, Stephanie. Based on the rulings we are aware of, as well as what we know about federal judges, she is probably one of the toughest, most adverse federal judges you could draw for this case.
Jack Smith.
But he was willing to risk it. He was clearly more willing to risk it, more worried about venue, more worried that this case would get tossed out by not filing it in the right place, that he was willing to take a gamble on Judge Cannon.
Jack Smith is a gambling man. Laura Jarrett, Stephanie Ruhle, Andrew Weissman, and Ari Melber, thank you for being here and lending your expertise.